Welcome. Good day. This is Professor Vera Pujol from the University of Central Florida, and welcome to Legal and Ethical Environment of Business. As I was saying in my last lecture, we've seen the difference now between civil and criminal liability, between state and federal law. And of course, we saw the very important procedural idea of due process. Everybody has to be treated fairly when they're accused of misconduct. In this last lecture on sources of law, I want to talk about the actual types of laws that you will see when you study the legal system and as we move along the semester. There are, in essence, three major areas of law beyond the distinctions we've seen already. One is going to be legislation and regulation. These are laws that are enacted, depending again whether you're talking about state or federal law. These are laws that are enacted by the Congress, for example, the Copyright Act or the Computer Fraud and Abuse Act, or laws that are enacted by the state. For example, in Florida, think of the Stand Your Ground law. The next major area of law is the common law. This is judge-made law. Judge-made law are principles that are elaborated by the courts and by judges as they resolve disputes and decide cases. Even cases brought under legislation, such as the Computer Fraud and Abuse Act, often have a high degree of a common law. For example, the Computer Fraud and Abuse Act makes it illegal to use a computer without authorization. Well, think about this. If you share your password, your Netflix password, with a friend or a family member, are you breaking the Computer Fraud and Abuse Act? Is that the use of a computer system without authorization? That's something the courts will have to decide when they interpret the Computer Fraud and Abuse Act. And it's that judicial interpretation of our laws that is considered common law. Now, what's really unique about the common law is that it has a really old history, going back to medieval England and the so-called common law courts. Those courts in turn inspired by a lot of Roman law sources. But the idea of common law is that judges, both state and federal, have interpreted actual legislation, and going back to England, have elaborated entire bodies of law, such as tort law, when somebody injures somebody else negligently or intentionally. That can be a tort, and those principles of tort law have been developed by the courts over the centuries. Same thing with breach of contract and what is a contract, things that we'll be studying in this course. Contract originally came out of the common law, judges deciding breach of contracts and contract disputes and elaborating general principles of laws. Now, the way the common law works and what makes the common law so special is a very important idea. Probably after due process, it's the second most important idea in our legal tradition. And that is the idea of precedent, or stare decisis. Let the decision stand. And the idea is that when a court makes a decision, it generally needs to stick to that decision the next time it decides a case that has similar facts. Now, there's a lot of complexities with stare decisis. Sometimes on really dramatic occasions, a court will overturn a previous precedent. But those are the exceptions that prove the rule. This is why the common law, judge-made law, is considered a very important source of law in our legal tradition. Finally, we've already seen legislation and common law, but I would like to mention natural law. Now, this is very controversial. Probably I'm in the minority in including natural law as a source of law. But think about the notion of human rights, or think about those famous words in the Declaration of Independence, that all men are created equal. Think of Martin Luther King's letter from a Birmingham jail. That is one of the most dramatic moments in our history, where Martin Luther King has been accused, right, of a crime of disrupting the peace in his effort to fight segregation, right? And in his letter, he's saying, well, he's obeying a higher law. Now, this is very controversial. What is this higher law? Where does it come from? Is it binding on us? Is it binding on judges, on legislatures? Well, let me just leave it at this. With natural law, it's a great way to segue to our last set of lectures, which are theories of ethics. Ultimately, we care about right and wrong. We care about ethics. We care about morality. And we'll leave for another day the question of what is the relationship between law and morality. That's a really hard question, and there is not a general consensus among legal scholars and legal philosophers, for example, on that question. But there are three major theories of ethics, and I'd like to describe and discuss those theories in our last 3 videos of this unit. Again, thank you for your attention. Have a great day, and go Knights.